licensing panel. My name is Councillor Jenny Fadgley and I am chair for this meeting. Please note that the meeting is also being broadcast live and members of the public are able to view the proceedings. Present with me are members of the licensing panel and I invite them to introduce themselves.
Hello, am I on? It's working. I'm Councillor Rock.
Good afternoon, I'm Councillor Ian Shenton.
Also present with me are Olivia Quinn, Democratic Services Officer, Ala Cronin, Legal Officer, and Janine Ray, Licensing Officer. We may now move to the agenda. Apologies for absence.
Chair, we've got no apologies.
Do any committee members have any interest that they would like to declare in relation to the item on the agenda?
Thank you, Chair. I know I have friends who live in Kings Lane, but I'm aware that we're not known to one another and I haven't discussed this with anyone in Kings Lane. So I come here with an open mind.
Thank you, Councillor Shenton. Councillor Rock.
I suppose I should say I do know somebody that lives in Ingon Lane, which is adjacent. Same thing as Councillor Shenton, otherwise.
I also know somebody who lives in Lincoln Lane, but haven't discussed this with anybody.
If anybody doesn't do so.
Yes. Absolutely. Thank you. So now I hand over to the licensing officer to present the application.
Thank you, Chair. Yes, so in front of the panel today for determination is an application for the variation of a premises licence for the Welcome Hills Vineyard, following one or more representations to the licensing objectives. So, as background information, Welcome Hills Vineyard is located on Kings Lane in Snitterfield. There are a number of residential dwellings and commercial properties within the vicinity, and we've given you a plan of the location at Appendix 1 so you can get an idea of where the vineyard sits. The venue was first granted a premises licence in 2021, and that licence is attached for you at Appendix 2 with the associated plan at Appendix 3. The extent of that original licence was fixed by a number of conditions, but Condition 17 specifically states the sale of alcohol for consumption on the premises shall not take place on more than 40 days each calendar year. This was a condition imposed by the applicant as part of that original application. The applicant has since operated on additional days to those 40 days under the authority of temporary event notices when that 40-day limit's been fulfilled. So on to this application. The application before you today seeks to remove Condition 17 in its entirety, and a copy of the application is attached at Appendix 4 for you. So on to responsible authority representations. We've received none. No representations have been received from any of the responsible authorities served a copy of the application. 2 representations were received in respect of the application from nearby residents. A copy of the representation from Mr. Thomas is attached for you at Appendix 5, and at Appendix 6 is the representation from Mrs. Force. Mrs. Force is here today to represent both parties on behalf of Mr. Thomas as well as herself. Noted here is that the panel should be mindful of the relevance of sections of these objections, which relate to matters of planning as opposed to licensing, so that's to be considered. Planning were consulted on the application, and we haven't received any representation from them. As additional items, the agent for the applicant, Mr. Semper, has supplied 2 supplemental documents since receiving the copies of the representations. So Appendix 7, which I'm sure he'll refer to, that's the crash map data, and Appendix 8 is a submission in relation to planning matters. As an aside, it's worth noting that the planning team have been forwarded copies of the representations and are undertaking their own investigations into those matters as a separate matter. So, on to the options available to the panel today. Having had regard to the application and any relevant representations, the panel should take such of the following steps, if any, as it considers appropriate for the promotion of the licensing objectives. You can modify the conditions of the licence or reject the whole or part of the application. So I'll now pass back to you, Chair, should you have any questions. Thank you.
Thank you. Do any of the panel have any questions for the licensing officer? Councillor Shenton.
Thank you, Chair. Janine, just a couple of quick ones. How many TENS licences have been issued?
Thank you. Yes, I thought that might come up. We've received so far 8 temporary event notices that cover 18 days. As far as I'm aware, some of those events haven't happened as yet, I believe.
You said you had 2 issues there. Please, for a second.
And just following on from that, there I notice in the documents it says there'd be no incidents, there's no footprint, if you like. Is that the same? That includes the TENS themselves, the ones that have been used up to now?
We haven't had any cause to contact the premises, no complaints that have been received directly to us.
Councillor Rock.
So if I may, I'll ask a supplementary on the previous question. So the implication is that thus far the need is 40 plus 18 days. There's been the demand so far, hence the desire to remove the existing constraint. And therefore, well, I'm sure we'll come to the applicant in due course, but as far as we know, we're looking something of the order of 50 to 60 is the sort of level that's been the demand thus far. And we're seeking to make it unlimited, 365 presumably.
Yeah, that's probably better to forward to the applicant as to what their intentions are going forward, but certainly I think that the demand has surpassed over the years what they've currently got, but I'm sure they'll elaborate further.
May I just check there are no more questions at this stage? Councillor.
Just one more follow-up on this. Highways, not had any kind of notification from highways. I know we've got a map in there. We've had no other communication from them about this.
The Highways Authority are not a responsible statutory authority under the Licensing Act, so they haven't directly been notified about this licensing application. That would come up more in matters of planning.
Councillor, no, sorry, Councillor Shenton. Right, Councillor Shenton, another question.
Just to just to extend that a little bit, and we've had nothing in here, and there is no nothing from the police who would have a right to put in comments.
No objections received from the police, no comment.
Councillor Rogg.
And a further follow-up from incisive questions from Councillor Shenton is that you've mentioned planning several times on that. Just to reiterate, I think what you said, the planning regulations and the licensing regulations are completely separate from our considerations.
They are separate matters with separate regulations. They are related, and that's why they get a consultation as part of any licence application.
No more questions now? Thank you very much. I now invite the agent, Nick Semper, to make their representation on behalf of the applicant, John Kelsey.
Good afternoon. Bit loud. Is that okay? Do you want me to sit back? Is that okay? That's better. I can hear myself coming back. Okay, well, I am Nick Semper from the licensing guys, and I'm representing the applicant here today, being Welcome Hills Vineyard, here represented by Jonathan Kelsey. By way of background, Welcome Hills Vineyard has been producing award-winning still and sparkling English wine now for over 20 years on probably an ideal microclimate for producing English wine as any that can be found in the English Midlands. It is as inoffensive an operation as it is innocuous. Run by husband and wife team, Jonathan and Nicola, they are open on selected dates for vineyard tours and English wine tasting events. The current premises license, as you've heard, was issued in this format on the 16th of March 2021. Since then, the business has continued to grow incrementally and steadily. The extent of the original license was fixed by Condition 17, which states that 40 days you've been hearing about. The applicant has still since operated on additional days under the authority of temporary event notices when that 40-day limit has been fulfilled. Okay. However, this 10 facility, this ability to apply for 10s, is finite in as much as it will give you 15 10s over 21 days. And this limitation is now constraining the growth of this successful and profitable business. It must be noted that these premises have operated successfully and quietly between 2021 and the present, without causing a footprint to any of the responsible authorities. As no additional augmentation to the licensable activities are entailed in the original grant are requested or entailed today, no further control measures in the form of additional conditions has been offered as part of this variation. So the application is therefore to remove Condition 17 in its entirety. As you'll be aware, each application must be judged on its own facts and merits. The significant merits of this application is that it's a quality premises which is operated with a zero footprint with responsible authorities to date, and has also operated in exactly the same terms as sought in this application under a succession of temporary event notices, not one of which has ever attracted a single incident or even the suggestion of noise, disorder, damage or accidents. In this hearing, the burden is on the applicant, Jonathan and myself, to show that the proposed operation, supported by the proposed operating schedule, which remains unchanged, is capable of promoting the licensing objectives and is unlikely to undermine them. Any representatives, on the other hand, opposing the application have the burden to show that these premises, trading under the operating schedule that's operated correctly since 2021, will undermine the licensing objectives and demonstrate that evidence if they are granted these extra days. In our submission, any subcommittee, properly advised, could only refuse this application if it is found, on the evidence of the representatives, not to be capable of promoting the licensing objectives. So you may ask yourself, why do the representatives, aka objectors, it's a polite word from why do the objectors need to produce evidence? The answer is found at para 9.43 of the section 182 guidance handed down to us by the Secretary of State under the Licensing Act 2003, which clearly states, and I quote, "The authority's decision, i.e. your decision here today, should be evidence-based, justified as being appropriate for the promotion of the licensing objectives and proportionate to what it is intended to achieve." End of quote. Significantly, there is not a shred of empirical evidence in the hearing papers today which challenges, criticises, or for the most part even references the operating schedule or this applicant or the designated premises supervisor whatsoever. This is an undeniable and self-evident fact. So let me first walk you through who has, or rather in this case, who has not objected to this variation application. Firstly, the police, being the lead responsible authority and source of expert evidence on all crime, disorder, ASB and road safety issues in Warwickshire. There is no representation from them. The licensing authority here in the presence of Janine, being the lead responsible authority for all licensing matters in Stratford, has made no representation. Trading Standards, Children's Services, the responsible authorities who protect children from harm, Public Health, who deal with harm to health from substance misuse, and the planning department, and indirectly the highways and road use functions within that department. Planning, they've raised no objection, and lastly, environmental health, the lead agency on public nuisance licensing objectives, all raised no objection. That is significant because this hearing is an evidence-based decision-making process. You as a committee in my submission cannot be insensible to the fact that not one of the lead and expert responsible authorities in this part of Warwickshire has objected to this application or has raised any evidence against it. You can therefore rightly assume in my submission that, in the opinion of all the responsible authorities, this operating schedule and proposition does not undermine the licensing objectives, otherwise they would be here in this room with evidence to argue vehemently against it. We are left then with 2 objections from members of the public. These no doubt come from good people, but we need to think carefully about what they are complaining about and how relevant those complaints or those fear and speculation of problems going on in future are relevant, how relevant they are to the current application that physically sits before you. Instead of dealing with each personally and thereby personalising it, I will break down the arguments raised in each by heading and will deal with each in turn, but the overview looks something very much like this. Both worry about near misses of vehicles in the lane outside. One worries about the likelihood of drink driving, and one questions the planning permission. Okay, traffic. Deal with traffic first. Traffic is not mentioned anywhere in the Licensing Act and receives no mention in the Section 182 guidance either. So in my submission, it is an irrelevant consideration. The police, planning department do not share these concerns. There is no evidence of road traffic collisions before you. In fact, to the contrary, I have served on you, stand by, this document here, which is the crash map data for the area. This data is amassed from police, ambulance and insurance company records and shows that there are no road traffic collisions in the vicinity. And even if there had have been, there is no causal link evidenced between any road traffic collision in the area and licensable activities at this site. However, we note the concern of the neighbours regarding delivery trucks, and that's a cause for concern. The reason why delivery trucks of this size are used is because consignments of wine are heavy and therefore need a vehicle that carries its own tail lift. However, these deliveries occur between 10 o'clock in the morning and 3:30 in the afternoon, and they only occur 4 or 5 times per year. Therefore, the obstruction to the highway, and that vehicle has a perfect right to park there, as anyone does, a right to pass and repass on a highway. Any obstruction to the highway from these deliveries is, in my submission, de minimis. Okay. The second objector also queries whether planning permission covers the activities on the site. I've served on you a brief submission explaining the judgment handed down on the 25th of June 1999 by their Honours Lady Justice Butler-Schloss and Lords Justice Shielman and Mansell in the case of Millington and the Secretary of State for the Environment, Transport and the Regions against, and Shrewsbury and Acton Borough Council were joined in that action. A very brief legal submission has been sent in, which will surely has gone to planning for them to look at. I'm sure your own planning department, although we hear they're conducting investigations, I'm sure they wouldn't necessarily go behind the judgment of these learned law lords, okay? And we have no evidence from them before you in any event. That's been served on you, so your legal advisor can help walk you through that in recess, should you require it. Okay, that case, in summary, sets a precedent that the selling of wine, public visits and tastings are ancillary activities for vineyards and does not require any form of planning permission. Incidentally, the planning authority, like I just hit that again, the planning authority has not objected to this application anyway. And in all eventualities, I point you to, your lawyer will want to make a note of this, para 14.64 of the section 182 guidance, which clearly states, and again I quote, planning permission, building control approval, and licensing regimes will be properly separated to avoid duplication and efficiency. Therefore, in my submission again, planning matters do not lie within the remit of this committee. I now very briefly need to talk to you about fear and speculation. I'm coming to an end, trust me. Okay, I know you've heard a lot, but I've just got to touch on this. It's important in case it ever needs to be raised upstream. Okay. The objectors, good people, they speculate that were you to grant the variation of this license today, then they fear that there may be problems of some shape or form at some undisclosed point in time in the future. There are two main reasons why fear and speculation are not admissible in these proceedings in my submission. Firstly, as I've already read to you, para 9.43 of the section 182 guidance clearly states that your decision today must be evidence-based. Fear and speculation about what might or might not happen at some undisclosed point in the future or as a consequence of any decision in this room today is not evidence. It is what it is fear and speculation. And secondly, there is the ruling in the case of Daniel Thwaites and Wirral magistrates that appeared before the High Court in 2008, where Her Honour Justice Black handed down a judgment. And in that judgment, there's all sorts of interesting things, but she says that you should be actuated, your decision-making in the room, I'm giving you a bottled version of it, please take advice from your legal advisor, that's what she's there for. But what the judgment says is you should be actuated by real and proper evidence. Okay. There is no history of problems with this applicant or his, or theirs, I should say, management of these premises, and the potential for any such issues is more than properly addressed in the proposed conditions which this panel handed down in 2021. Now, in any event, Parliament has already provided a mechanism to deal with future problems emanating from licensable activities at this or indeed any licensed premises, which you're already aware of. It's called the Section 51 Review Procedure under the Licensing Act. Were you to grant this variation today, and were problems to ensue, and I assure you as best as I can, and on their behalf that they will not, then the mechanism to control that is self-evidently provided through the lawful and correct manner with the legislation within the Section 51 procedure. So with your permission, I will leave it there and deal with any of your questions as they come up or in summary. Thank you.
Thank you, Mr. Semper. Do any of the panel have any questions for Mr. Semper?
Thank you, Chair. Just one very quick question. In terms of the party sizes, can you give us a flavour of the average size of the group of people and the number of vehicles that we would expect to see in any one party? I know that's a bit vague, but give me a flavour, that would be great.
So for each tour, we average somewhere between 20 and 24 people. We sell a maximum of 24 tickets. There's the odd tour on a very sunny day where we've had a waiting list where we've gone up to 25, 26 when we're going to be outside, but it's been no more than that, and probably the average is somewhere around 20 to 22. We actually get quite a few.
He also asked how many vehicles.
Yeah. Vehicles is a bit harder to track, but I can just give you my best view of it, and it depends. During the sort of sunny months, we get a few more people walking across the Welcome Hills. Our parties tend to be between 2 and 4 people, so most people are coming in couples, some come in fours. And so I'd say from a normal tour, we could get up to 10 vehicles. Some of those are staying, some of those are dropping off, and some of those are taxis. But that's a rough, as close as I can get to.
Good.
Are there any more questions? Does Mr. Semper have any further comments to add at this stage?
I'm sure I've got plenty to say after I've heard from these other good people by way of reassurance or explanation, but I have nothing at this time, ma'am.
Thank you. I now invite Ms. Force to make their representations on behalf of herself and Ivor Thomas.
Thank you, ladies and gentlemen. Nothing exists in a vacuum, and the vineyard doesn't exist in a vacuum or even a business park. It exists on a residential country lane, as I'm sure you've seen from the photograph, which is part of your appendix today. Although it's a country lane, it does have a speed limit of 60 miles an hour, which many consider excessive, but that is not for discussion today. The grounds of my objection and of my neighbour, Mr. Thomas, are on the grounds of public safety, and this is to do with vehicles entering and exiting the vineyard. There, as Mr. Semper has rightly said, there have been no accidents, no police have been called, but the number of vehicles entering and exiting is obviously going to increase if more licensing days are allowed. That much is obvious. The problem with the entry to the vineyard is that it is on a blind bend. It is between two bends, so it's a sort of S shape, and exiting the vineyard to the right. This is traffic coming from the east end of King's Lane. Both the traffic coming towards the vineyard cannot see any vehicle exiting that vineyard, and the vehicles themselves exiting the vineyard cannot see to the right anything coming, potentially at 60 miles an hour. And people do drive at 60 miles an hour. Added to that, the hazard of taxis, Ubers, dropping people off. The people who drive themselves to the vineyard tend to drive into the property, and that is much less dangerous. We, as you've seen from the map, do live opposite the vineyard, so we can see very clearly what happens if you're out there gardening, whatever. But the taxis and any goods vehicles deliveries do not drive into the vineyard by and large. They stop on the road. They are therefore on the highway, causing an obstruction. I'm not just talking about the large HGVs, which come, as you just said, maybe 4 times a year. I'm talking about the regular vehicles that stop to drop people off where they don't quite know where they're going, so they're slowing down. Anyone coming up behind them, this is a potential accident. As they are waiting to pick people up, sometimes they're on the wrong side of the road. Anyone coming behind them who is impatient will just overtake them. They find themselves on the wrong side of the road going into a blind bend. So the fact that there have not been any accidents and that I am talking about fear and speculation, as has been said before, does not mean this is not something to do with public safety. All the residents of King's Lane are nervous about traffic and safety because there is no pedestrian walkway. We all have to walk in the road. And anything that adds to the danger of living there is, of course, our concern. There have been no issues, as I say, with the vineyard, but the entry, the exit point to that property is a danger and is a spark point for future traffic accidents. And I would urge you to think about that consideration when we're thinking about public safety. My neighbour, Mr. Thomas, who cannot be here today but has asked me to represent him, has further raised public nuisance by the sheer number of people, which is not an enormous amount at the moment, but of course if the license for just 40 days plus the 18 temporary is extended to 365 potentially, then we have many, many more people coming and going with their vehicles, with their taxis, and perhaps even more wine being delivered in an HGV, I don't know. I have no evidence from highways or police to bring you on this because I am just a resident, perhaps with fear and speculation of what might happen, but we all have heard the blaring horns. We all have seen the near misses. And surely we don't want to wait till one of those results in an accident, because it will at some point. And yes, that is my submission. Thank you very much.
Ms Falls. Any of the panel wish to ask questions? No? Oh, Councillor.
Hi. Just a very quick one. By any chance, do you, you've mentioned that horns are being sounded and it's dangerous, and I know the road well, but do you have a log of incidents?
No, I don't. I've never really felt the need to keep a log. I assumed, I think, that the vineyard was going to continue operating at the level that he's had, which I think has caused a little bit of worry, but it's sort of acceptable. We sort of think it's okay at the rate it's going along, but the taking away of the 40 limitation with the potential to it be 365 days is about 10 steps too far. So no, I don't have a log, but I shall start one. Thank you.
Any further questions? Councillor Rock.
You mentioned the fear and speculation, as did the proponents of the application. And you said if it was going along as it is, the implication is you've been content with that. And you mentioned 365, which is a number that I said, because if it's unrestricted, that's the implication of that. Presumably there's some, in your mind, is there some middle date, middle number of days that you think might be appropriate?
Well, I think it depends when it's happening. I mean, the vineyard days at the moment tend to be at the weekend. So I guess the implication from that is, are we looking at every weekend, which is the time when there is perhaps more leisure driving along the lane? Because as you know, at the end of the lane, we already have the farm shop. They have a much safer entry. They have a large parking area, but it does mean more traffic. If the vineyard opening days are to be every weekend, every Saturday, every Sunday, 2 or 3 times a day each day, would I be content with that? No, I have to say I would not. At the moment, it is the weekends in the summer and other occasional days, but definitely has become much more often.
Thank you. Thank you for that. Are there any more questions? Councillor.
Just thinking about neighbours, because I know you and your neighbour have put in objections. The other neighbours along the road, from Cobbs right the way through to the other end, how do they feel? Could you say how you think they feel? And also, Cobbs obviously brings a lot of traffic down that road itself, and there hasn't been...
Excuse me, may I just ask guidance from our solicitor, please?
To speculate, yeah. So in terms of the, just strike the first question, but in terms of the volume of traffic, obviously it was called the farm. I think it's now Cobbs, isn't it? It's called, and there's a volume of traffic associated with that. But you haven't, I think by your own admission, you haven't seen any increase in incidents because of that traffic, because some of that traffic would come from Ingon Lane rather than the A46 end, which is obviously the safer end, isn't it?
It would, and I would say that as soon as the farm shop opened, we've been watching the traffic because we did fear that it was going to be, bumper to bumper along King's Lane. And the farm shop have tried very hard to direct traffic leaving the farm to turn left onto the A46. And it is my observation that the vast majority of traffic from the farm does turn left. So it doesn't come back along King's Lane. What has changed since the farm shop opened is the volume of pedestrian traffic, because people from the village of Snitterfield, shall we take a walk to the farm shop? So we have more people, children with bikes, mums with buggies, walking along the lane, which is actually not a very safe thing to do, given it's a 60-mile-an-hour speed limit and no pavement. So, yes, there is an increase in traffic, and yes, there is definitely an increase in pedestrian traffic.
Thank you. Councillor Rock?
In our preamble here with the licensing officer, there was a discussion about the planning regulations and the licensing regulations are separate but associated. Clearly there's that association and yet separate consideration is something we have to have in our minds. And some of the points that are being made here cross those boundaries. So you're perceiving that, are you, in your representation?
Well, I think it's hard to see how they can be unconnected, since, as I said, the vineyard doesn't exist in a vacuum. It exists in a place where other people live. And although we are told these things are separate, they have to be connected, because the vineyard and the work that happens with inviting people in, with the traffic to taste the wine, to drink the wine, has an impact on the area in which it exists.
Thank you for that. Any more questions? Thank you. Is there anyone wishing to make any final comments? Are there any further questions from the panel? Can I just ask a question, please? When people arrive in their cars, there is adequate car parking space for the cars that you expect to come. Can I also ask, when the delivery van comes, do they actually move off the road to make their deliveries not from the road but from your premise?
So the larger HGV, no, it stays roadside for about, well, depending on how many things come off, it's about 20 minutes to 30 minutes to unload. It happens about 5 times a year. It depends how much wine's being made and how much comes back, I guess, around that. The other delivery vehicles, of which aren't always related to the vineyard is also our house. So we pretty much daily have Amazon, you name it, but not just for us. Quite often they'll use our driveway, and vice versa, to be fair, to drop off at other locations. A postman does the same. So that's quite a frequent occurrence, but that's normally during the day.
Thank you. Right, no more questions to be asked? Councillor Shenton.
One quick one. Are there any restrictions on loading or unloading on that road?
Not that I'm aware of. There's about...
That's fine, not that you're aware of.
Okay. Yeah.
Thank you. We're looking for the final comments from...
Do the representatives go first on final comments, or is it just me? Every county,
Yes.
every authority is going to differ.
A slightly different way of doing things, yes.
So
Yeah.
if it's summing up, I believe I should go last.
Yeah, I agree. I think the objectors should go first, and then someone the applicant speak first before we go to the applicant to sum up.
So, do the objectors wish to make a final statement, and then we'll go to Mr. Sumper?
I think I would just say, in summary, I don't want to repeat myself, you have heard my points, but I would just like to emphasise that this is a road with a 60-mile-an-hour limit, and the number of vehicles entering and leaving the vineyard, especially the big vehicles that block the road, even though it's not very often, are all potential public safety hazards. And I don't think we should be adding to public safety. I think safety hazards. I think we should be seeking to make the place safer for all its residents and for all the people who use it, some of those who are pedestrians as well.
Thank you. May we move to Mr. Sumper, please?
Certainly, thanks. Okay, the only question I was going to ask is that we've been told the vineyard doesn't exist in a vacuum, and this is a residential country lane. My information is there are 11 other businesses down that lane, some of which are substantial and create an awful lot more traffic than this particular ones. Okay, that's the first thing. Secondly, I would point out, and this is an important concept to get, today 10 vehicles will go on and off this car park, okay, with 24 people in. Since 2021, there's not been an accident. But that can only happen on 61 days a year to a maximum. Why on day 62 should 10 vehicles and 24 people pulling on and off this vineyard suddenly cause an accident? It won't. The risk only goes up if the volume of vehicles goes up. And the volume of vehicles at any one particular time will not go up. Now, the third thing is, I don't know, well, I do know why. I just thought I'd make that point because it's important. But Mrs. Force has addressed you very comprehensively, all about public safety. Her issue, she's told you 3 times, I think now, this is all to do with public safety. And in common parlance, she would be right. The traffic out on the road would be a matter of public safety. But unfortunately, we're in a licensing act. Your powers all come from the licensing act, not from planning, not from anywhere else. That is the act under which you are formed, and these are the powers you must apply. Public safety for the purposes of the licensing act refers to the safety of people using the premises for licensable activities. None of these people going by outside on horses or walking or bikes or going 60 or whatever. Road safety, okay, no doubt about it. But it's not part of the public safety licensing objective laid down by the Act. That's why you have planning and highways departments to deal with these things. So with respect, she's come to the wrong committee to argue about, or the wrong authorities to argue about traffic, okay? The authority for that, ma'am, I'm talking to your legal advisor, is para 2.1 of the section 182 guidance, where public safety as concerns what goes on in these hearings is defined there. Okay, so look, yeah, I've got something to say to you just in summary, and I'm going to be quick. This hearing needs to remind you, this hearing needs to remind everyone actually, this hearing is simply about whether this established and reputable operator against whom you have heard nothing to its detriment, operating this quality vineyard within these hours in accordance with this operating schedule, which to date, since 2021, has caused no problems to anybody for 40 days a year, and then has traded an additional 21 days that year, per calendar year, without causing any problems to anyone. Whether this operation, supported by the comprehensive raft of conditions, will undermine the licensing objectives, or whether it will promote them. Very clearly, our position is that it will not undermine them. There is no evidence of public nuisance, crime or disorder, or road traffic collisions, or indeed any other cause for concern regarding the promotion of the licensing objectives, as I have explained them to you, evidenced involving this application or this applicant before you. That, I'm afraid, for Mrs. Force, is an undeniable and self-evident fact. So consequently, I do respectfully, panel, request that you do indeed grant this application for a variation for the premises licence as sought, and that you wish Jonathan and Nicola every ongoing success with growing their established and successful Welcome Hills vineyard. Thank you very much.
Thank you for that. No more questions for that. We are now moving into deliberation, and parties will be advised of the decision within 5 working days. Thank you all for attending the meeting today. Item 5 on the agenda, is there any urgent business?
No, Chair.
No urgent business.
Could I just ask, is there a possibility that this is an indication of your judgment today? I don't know how long it will take you to make an answer.
My experience in the past is if we come to a rapid conclusion, you would be informed more rapidly than 5 working days. That's the longest that you could. Thank you. Thank you. End of the meeting.